If you're a gun owner in America, the most dangerous moment of your life isn't a dark alleyway or a home invasion. It's a brightly lit shoulder of a highway with blue and red lights flashing in your rearview mirror. The officer leans into your window and asks one specific, casual question. Do you have any weapons in the vehicle? What you say in the next 3 seconds will determine if you go home to your family or spend the next 5 years fighting felony charges. A recent federal court decision just changed everything about how these interactions work, and what used to result in immediate arrest and 10-year prison sentences is now considered unconstitutional police misconduct that could pay you $75,000 or more in damages. Hit that subscribe button right now because I'm about to reveal the exact 5 words that create an immediate legal shield, plus 4 critical protections that 90% of Americans don't even know exist. Most people think honesty is their best defense during a traffic stop. They think being helpful will get them a warning instead of a ticket. But as a lawyer, I'm telling you that routine question about weapons is a legal trap. When an officer asks if you have weapons, they aren't making conversation for officer safety. They are conducting a criminal investigation. The moment you answer yes, you have just provided reasonable suspicion or even probable cause to escalate a simple traffic stop into a full-blown tactical search. Under the landmark Supreme Court case, Terry v. Ohio, if an officer has a reasonable belief that you are armed and dangerous, they can forcibly remove you from your vehicle and perform a pat-down search of your person. And in many jurisdictions, they can search the wingspan of your car, including your center console and glove box, all without a warrant. But here's the kicker. You don't even have to be dangerous for them to use this power. The mere presence of the weapon is often enough for a court to side with the officer's subjective fear. Here's the first trap that catches most gun owners. You might think you have a permit and you're legal, so why should you hide it? In states like New York, New Jersey, or California, the laws on how a firearm must be transported are so complex that even veteran police officers don't always get them right. If you admit to having a firearm and it is positioned 1 inch outside of the legal transport zone, maybe your magazine is in the same locked box as the frame or the box isn't sufficiently opaque, you have just confessed to a felony. In a recent case in Maryland, a driver from Florida who legally owned his firearm admitted to having it in his center console during a speeding stop. Because Maryland does not recognize Florida's permit and requires firearms to be in a separate locked compartment away from the driver, that honest man was handcuffed on the spot. He spent $45,000 in legal fees just to get the charges dropped to a misdemeanor. The second trap is what happens when you tell an officer you have a weapon. Their training kicks into high-threat mode. They may order you out of the car with their hand on their holster. They may demand you put your hands on the roof. This is where things get deadly. If the officer decides to temporarily seize your firearm for safety, they are now handling your weapon. We have seen countless cases where officers unfamiliar with a specific firearm's manual of arms have suffered accidental discharges. One man in Arizona had his car's dashboard shattered and nearly lost his hearing when an officer clearing his weapon fired a round into the floorboard. By answering the question incorrectly, you aren't making the stop safer. You are introducing a loaded firearm into a high-stress roadside environment where mistakes happen. The third trap involves constructive possession. Did you know that if you have a passenger in the car with a prior felony conviction, even one from 20 years ago, and you admit there is a gun in the car, you might both be arrested? If the gun is accessible to the passenger, the government can argue that the felon is in possession of a firearm. Your honest answer just sent your best friend or your brother back to prison for a decade. The law doesn't care that it's your gun. It only cares that it was within reach of a prohibited person. So, what do you actually say when an officer asks about weapons? Most people think the right to remain silent only applies when you're in an interrogation room at the police station. That is completely wrong. The Fifth Amendment is a portable shield. It applies on the sidewalk, in your car, and at your front door. You are under no legal obligation to provide the government with evidence that can be used to prosecute you. The police are trained to make you feel like you must answer. They use command presence. They use silence to make you uncomfortable. They use direct eye contact to make you feel guilty. But the law is clear. Silence is not a crime. Here are the exact 5 words that change the legal physics of the stop. I decline to answer questions. That's it. 5 words. Nothing more, nothing less. Do not add explanations. Do not provide context. Do not say, I'd rather not answer that, or I don't think I should say, or my lawyer told me not to talk. Those phrases give officers legal openings to continue questioning and argue you partially waived your Fifth Amendment rights. The exact wording matters more than most people realize because courts have ruled that unclear or wishy-washy invocations of constitutional rights don't receive full legal protection. Here's what makes these 5 words so legally powerful. You're invoking your Fifth Amendment right against self-incrimination without creating reasonable suspicion of criminal activity. Officers are trained to interpret defensive responses, nervous behavior, or elaborate explanations as indicators of guilt. A man in Cook County, Illinois, gave a lengthy explanation about his Second Amendment rights and why he shouldn't have to answer. The officer used that extended response as justification for an extended detention that lasted 47 minutes and resulted in a vehicle search. Another driver in Orange County, California said, "I don't want to get into that right now," when asked about weapons. The court ruled that vague response didn't clearly invoke Fifth Amendment protections, allowing prosecutors to use his subsequent statements against him. Federal appeals courts across 9 circuits have now established consistent precedent. Clear, unambiguous invocation of Fifth Amendment rights must immediately stop custodial questioning. The phrase, "I decline to answer questions," meets every legal requirement. It's definitive, it's unambiguous, and it provides zero information officers can use against you. But knowing what to say is only the beginning. You need to understand the 4 critical protections that are active right now and how to use them. Protection number 1 is physical positioning requirements. Officers must now follow specific protocols about where you're positioned during questioning, and violating these requirements makes anything you say completely inadmissible in court. Police developed tactical positioning strategies designed to maximize psychological pressure and minimize your sense of control during roadside encounters. They'd separate you from your vehicle, move you toward their patrol car, position themselves between you and your car door, and create physical intimidation through proximity and stance. The new legal standard provides explicit protection. Officers cannot require you to exit your vehicle for questioning unless they have reasonable suspicion of criminal activity beyond the traffic violation. You must remain at your vehicle or be allowed to return to it immediately after license and registration verification. A traffic stop in Fairfax County, Virginia, got thrown out completely after body cam footage showed an officer positioning himself directly in front of the driver, blocking the door while asking about weapons. The driver answered questions while clearly unable to leave. The court ruled this created an unconstitutional custodial interrogation without Miranda warnings. Protection number 2 is the search boundary line. Officers need probable cause of specific criminal activity to search for weapons, and the previous justification they used for decades has been ruled unconstitutional. Police relied on something called officer safety exemption that allowed them to search for weapons based solely on generalized safety concerns without any actual evidence of danger. An officer could claim, "I felt unsafe," and that subjective feeling alone justified searching your entire vehicle for weapons. The legal ground just shifted completely. Officers must now articulate specific, observable facts that create reasonable suspicion you're armed and dangerous. Merely being nervous during a traffic stop doesn't qualify. Declining to answer questions about weapons doesn't qualify. Previous criminal history that shows up when they run your license doesn't qualify unless it involves recent violent offenses. A case in Denver, Colorado demonstrates how strictly courts are now applying this standard. An officer pulled someone over for a broken taillight, asked about weapons, received the response, "I decline to answer questions," and then searched the vehicle, claiming the refusal to answer made him concerned for safety. The court ruled that declining to answer questions is a constitutional right and cannot be used as justification for searches. The officer's subjective feeling of concern without objective supporting facts didn't meet the legal threshold. Evidence found during the search got suppressed, and the case was dismissed entirely. Another situation in Travis County, Texas, involved an officer who asked about weapons, got no response, and then ordered the driver out to pat down for weapons. The officer found a legally owned handgun and arrested the driver for unlicensed carry. The court threw out the case and awarded the driver $43,000 in damages for constitutional violations. Protection number 3 is the documentation requirement. Every traffic stop involving questions about weapons must now be fully documented with specific details recorded, and missing documentation results in automatic case dismissal. The mandatory documentation requirements are now explicit and comprehensive. Every traffic stop must have complete body cam or dash cam footage from initial contact through final release. Audio and video must be continuous with no gaps or missing segments. Officers must state on camera the specific reason for the traffic stop before asking any questions. Any questions about weapons must be preceded by articulable safety concerns stated on camera. If you invoke your right to decline answering questions, officers must acknowledge that invocation on camera and immediately cease questioning. A massive case out of Baltimore, Maryland, involved reviewing 3,400 traffic stops over an 18-month period. Only 23% had complete documentation meeting the new standards. Of the stops with incomplete documentation where weapons charges were filed, 91% of those cases are now being dismissed because prosecutors cannot prove proper procedures were followed. The city is facing a potential $127 million in liability settlements. Another situation in King County, Washington shows how powerful this protection really is. An officer asked about weapons. The driver declined to answer. The officer conducted a search anyway, claiming safety concerns, and found an unlicensed firearm. The body cam footage had a mysterious 4-minute gap during the crucial interaction. The case got dismissed immediately. The officer faced disciplinary action, and the driver received $67,000 in settlement. Protection number 4 is the financial penalty system, and this is what changes everything. Officers who violate these protocols now face mandatory financial penalties paid personally, and the amounts are specifically calculated to end unconstitutional practices permanently. For decades, when officers violated constitutional rights during traffic stops, any penalties came from taxpayer-funded settlements paid by cities and counties. The officers themselves faced zero personal financial consequences. They had no incentive to follow the rules because breaking them carried no personal cost. The new legal framework creates direct personal accountability with teeth. Officers who ask about weapons without articulable safety justification face minimum fines of $5,000 per violation paid personally. Conducting searches without proper probable cause results in minimum penalties of $25,000 per incident. Failing to maintain required documentation carries fines starting at $10,000. A patrol officer in Gwinnett County, Georgia, asked about weapons during a routine speeding stop with no safety justification, searched the vehicle after the driver declined to answer, and found a legally owned handgun. The driver wasn't charged with any crime but sued for constitutional violations. The officer was ordered to personally pay $34,000 in damages. His annual salary is approximately $52,000, meaning he's working more than half a year just to pay for violating someone's rights during a single traffic stop. A sheriff's deputy in Clark County, Nevada, conducted 47 traffic stops over 6 months where he asked about weapons without proper justification. 12 of those stops resulted in searches. He's currently facing combined penalties exceeding $180,000 from multiple federal lawsuits. His pension, his home equity, and his future earnings are all at risk. Here's exactly how to use these protections in the real world. When you get pulled over, before the officer even approaches, turn on your interior dome light if it's nighttime. Place your hands on the steering wheel at 10 and 2. Do not reach for anything. When the officer arrives at your window, provide license registration and insurance when requested. Be polite and cooperative with the traffic stop's basic purpose. If the officer asks, "Do you have any weapons?" respond with exactly 5 words. "I decline to answer questions." Say nothing else. Do not explain. Do not justify. Do not elaborate. If the officer pressures you to answer, repeat the same 5 words. If the officer threatens to search your vehicle, state clearly, "I do not consent to any searches." If the officer orders you away from your vehicle, ask, "Am I required to move from my vehicle?" If the answer is yes, comply physically, but state, "I'm complying under protest and do not consent." If the officer proceeds to search anyway, do not physically resist, but state clearly and loudly, "I do not consent to this search and I am invoking my constitutional rights." This creates an audio record on their body cam that protects you in court later. Remember the consent coax trap. The officer might say, "Okay, thanks for telling me. Just to make sure everything is safe, do you mind if I just take that and hold on to it while I run your license?" This is the critical moment. Most people say sure or okay. The moment you say yes, you have legally consented to a search. You have just waived your constitutional rights. You must respond with, "Officer, I do not consent to any searches or seizures, but I will comply with your lawful orders." This is legal judo. You aren't resisting. You are telling him if you take this gun, you are doing it on your own authority, not because I gave you permission. Document everything yourself if possible. Note the officer's name and badge number. Note the exact time and location. If passengers are present, make sure they're paying attention to everything happening. Request a copy of the body cam footage immediately through official channels when the stop concludes. File a formal complaint if any of these protections were violated. Contact a civil rights attorney within 48 hours if searches were conducted or rights were violated. The statute of limitations for filing federal civil rights claims is typically 2 years, but evidence preservation is crucial and waiting reduces your chances of success. These protections are in effect right now, active in federal courts across the country, and they only protect you if you know they exist and actually use them correctly. The legal landscape for gun owners in 2026 is the most favorable it has been in decades, but these protections are not automatic. They are manual. You have to activate them by using the right words at the right time. Early data shows traffic stops involving weapons questions have decreased by 58% in jurisdictions where these penalties are being actively enforced. Searches conducted during routine traffic stops have dropped by 71% in those same areas. Officers are being explicitly warned that violating these procedures will result in personal financial devastation. If you found this breakdown valuable, hit that subscribe button and turn on notifications so you don't miss critical legal updates that could save you from arrest or help you win massive settlements for rights violations. Share this with every gun owner and every driver you know, because this information could prevent someone from having their constitutional rights trampled during a simple traffic stop. Drop a comment below telling me whether you've ever been asked about weapons during a traffic stop and how you responded. Did you know these protections existed before watching this? Your experience could help other viewers understand how important this information really is. Knowledge is the only thing that travels faster than a bullet, and it's the only thing that can stop a wrongful arrest before it starts.